Mr. Guthrie, as you are aware, the court proposes to hold a minute's silence at 11 o'clock. That clock is, I think, a little bit slow, in memory of the people who were killed in the atrocity in Nice. And we'll call the case on after that. So there will be an announcement in a moment or two's time. Thank you.
Ladies and gentlemen, nations across Europe have been invited to observe a 1 minute silence at 11 o'clock today to remember those killed and injured in the terrorist attack in Nice last week. As the time is now approaching 11 o'clock, we ask all those in the building at this time to stop what they are doing and stand in a moment of remembrance. I will announce when the minute is over. It is now 11 o'clock. One minute has passed. Thank you for your mark of respect.
Hearing an appeal, the Attorney General and Hall.
Yes, Mr. Guthrie.
My Lady, I appear for the Attorney General, who is the appellant in this matter. The respondent, as I think you're aware, is not represented. I assume, as usual, that the board has had the opportunity of at least seeing what it is that concerns the Attorney General in this case.
We understand the problem. We're having much more difficulty understanding an answer.
Well, my lady, I shall do my best. The respondent, as you know, was convicted in March of 2014 after what seemed at the time an unexceptional trial before a judge and jury in the Supreme Court. She appealed on a number of, so to speak, conventional grounds, which were replaced by an amended notice of appeal in July 2015, which was filed on the 25th of August 2015. And the reference to that in the record is at page 199. It is ground one at page 200 with which we're concerned, that the trial judge erred in law when he accepted that the matter was properly before him for trial and therefore presided over the matter. And I repeat, that was not a point which had been taken at any stage, either when the matter was first before the magistrate or first before the judge, or
But
during the trial.
As the Supreme Court of the United Kingdom knows only too well, that's neither here nor there. If it's a jurisdiction point, it's a jurisdiction point.
Well, I respectfully have to agree. It might be useful just to look at the way in which the Court of Appeal described the problem when they granted leave to appeal to your Ladyship's board. There's a separate judgment at that point, and it is at page 512 of the electronic record.
I couldn't find a copy of the judgment on permission to appeal in the bundle, but we've got a...
I think you may have a separate copy of it. I was shown one this morning.
Well, exactly. I was going to say, we've got a most admirable judicial assistant, Mr. Turner, and he, when this was pointed out to him, he said that he would be able to supply each of us with a loose copy.
It is in the electronic bundle.
It was also annexed to...
It was
It was annexed to the case of the appellant.
To my case as well.
Tab 1 to the case of the appellant.
Well, then I apologise.
Yes, that's right.
It seems as though you may have three copies.
And it's on the electronic thing, but what it wasn't was on the print in the printed bundle.
Oh, well, I'm so sorry, but it actually...
Well, it was ironic, wasn't it? Because Miss Justice Crane Scott was the Justice of Appeal who gave the judgment in the main appeal.
Yes.
And of course, she dissented from the decision to grant permission to appeal.
Yes.
And funnily enough, if you read the argument on permission to appeal, she says at one stage, but let their lordships deal with it. I'm quite prepared for that. But then she had second thoughts.
Well, I think, in fairness to her, the reason that she was against granting leave was, well, in part that she considered it was a matter which had already been decided before the present case in two other cases which we'll look at, called Kenzo Kemp and Rafe Ward. But she also thought there wasn't a matter of public importance for the purposes of the Constitution. So I don't think she was necessarily just, so to speak, sticking up for her decision in the court below. But in any event, the basis for the grant of leave is summarised in the decision which the President, Dame Allen, gave. And I'm using the electronic bundle, but it's paragraphs 2 to 5 of the decision. The Attorney General's grounds for the application are that the court's decision was erroneous and negatively impacts the Attorney General's ability to issue voluntary bills of indictment charging offences not only under the Trafficking Persons Act, but also under other criminal statutes, namely the Dangerous Drugs Act, the Firearms Act, and others. In my view, these grounds clearly raise significant points of law, namely the interpretation and reconciliation of various provisions of the Criminal Procedure Code and the Trafficking in Persons Act. Specifically, it raises the issue of whether the discretion under Section 2581, a discretion which appears to be rooted in Article 78 of the Constitution, is fettered by the definition of the phrase indictable offence in Section 2 of the Criminal Procedure Code. In other words, it turns on whether a true construction of all the provisions Parliament intended to create two groups of indictable and or summary offences, one of which allows for the selection of the mode of trial by the persons charged, it's the third schedule, and the other of which allows for such selection by the Attorney General under Section 2581, or indeed whether on a true construction Parliament intended to create only one group of such offences under the third schedule as the court found.
That seemed to me to be the key question.
Yes.
Well, if it's a voluntary bill, the consequence is not only that the case gets to the Supreme Court, but also that it gets there bypassing any preliminary examination in the Magistrates' Court, isn't it?
Yes, and I don't think it would be controversial. I don't think for me to say that the voluntary bill procedure is popular in the Bahamas.
Yes.
And it's not really on all fours with what we've come to regard as being the circumstances for a voluntary bill. And of course, in the Bahamas...
Sorry, you said it was popular in...
Yes, it is. Well,
popular with whom?
Well, it's used a lot. That's all I mean. Well, perhaps popular's begging a question.
Yes.
Well, it's chosen by...
Anyway, it's used a lot.
It's used a lot. And you should also realise that in the Bahamas, there's no similar procedure to the current arrangements here for sending cases to trial, which avoid the old form of committal. And we will see in due course, but the voluntary bill procedure is very wide indeed. And I don't think the issue as to whether it avoids the preliminary inquiry really comes into play because, well, it's certainly not adverted to by the Court of Appeal.
May well be one of the reasons why it's much used. I don't know, but it might be.
Yes, but whether it's an issue in the present appeal may be more doubtful because the Court of Appeal simply really considered it couldn't be used.
When you say the voluntary bill indictment process is much used, are you referring to section 256 or 258?
258 I was referring to there.
And how does 258 fit with 256? When's one used and not the other?
Can I come to that when I
Right.
at a slightly later stage? The place I wanted to start, if I may, is the Trafficking in Persons Act itself. And the indictment is at page 3 to 5 of the record, and you'll see that the offences charged are under section 3 and section 4, and we have the act itself at a bundle of authorities, pages 524, which is divider 1 of the paper bundle, and page 524 of the electronic bundle. And the offences which Parliament has enacted under section 3, whoever engages in or conspires to engage in or attempts to engage in...
I don't think you need to read these things out. They're all fully set out in your case.
Yes.
We've got more important problems to get on to.
Well, the point that one makes is that they on any ordinary understanding of the language, create indictable offences, because that, in the Bahamas, is all that a trial on information means. Yeah. There's a very neat little passage in the argument before the Court of Appeal which underlines that, where Mr. Justice of Appeal Conte...
Well, you've seen that in your
You've
case.
seen that, so I needn't take you to that. But
I mean, the problem is not whether they're intended to be indictable for the purpose of this Act, but whether that gets you a home under the Procedure Act.
Well, one answer which I would recommend is that it does, because if Parliament have made it quite clear in that Act that indictable, that the offences are indictable, then that ought to be the result. The first point we make is that the observations made by the Court of Appeal about that are unsatisfactory with respect to the Court of Appeal. The judgment of the Court of Appeal is at page 373, where we have the head note there. But if I can ask you to go to the Court's findings with respect to those provisions of the Trafficking in Persons Act, it's paragraphs 37 and 38 that I wanted to show you, which are on pages 386 and 387. Where the Court says we're satisfied that sections 3 and 4 of the Act are evidently hybrid in nature, insofar as penalties have clearly been prescribed in the event of a summary conviction or a conviction on information. However, both sections stop short of expressly designating the offences as either indictable or summary. The sections simply set out the conduct which is prescribed by law and stipulate penalties which can be imposed whether upon summary conviction or upon conviction on information. And then in paragraph 38, as regards the procedure, we're satisfied that while the provision of the penalties in the event of a summary conviction or conviction on information might, as Mr. Gaskin, who was appearing for the Crown, tend to suggest that Parliament intended that sections 3 and 4 were to be capable of trial either way, it is evident that the necessary parliamentary action has not yet been taken to amend the third schedule of the Criminal Procedure Code. And we say that the words used by the Court of Appeal are an inadequate description of the effects of section 3 and 4, because the intention to make the offences triable on indictment or indictable offences is the only way in which the legislation can be reasonably understood. It's not a question of stopping short.
Why could it not have been intended to create electable either way offences, which would then be brought into the schedule to section 214?
Well, it could have been, but it wasn't.
I know.
And this leads us to the question, which I think my lady has identified as being the important question, as to whether Parliament should be taken to have been intending that or not. And when one looks closely at the Criminal Procedure Code, one sees that the categorization used by the Court of Appeal, that effectively there is a threefold description which can be applied to all offences, is an oversimplification.
Yeah, I mean, your problem is the definition of indictable, isn't it? And
it's only the word "only" which is my problem.
Tell me, Mr. Guthrie, I'm sure you're coming to it, and if you want to come to it later, do, but the thing which is troubling me is this. Is it your case that the effect of the Court of Appeal decision is to prevent offences under Section 3 from ever being tried in the Supreme Court by a jury?
As it stands, that would appear to be the case.
Well, is it?
Well, certainly...
Their decision is that there can't be a voluntary bill, and it's certainly clear that there isn't a right of election.
Yes.
But that may not necessarily conclude the question of whether the Crown can go to the Magistrates' Court and say, here is a serious case, it ought to be tried in the Supreme Court by jury, and the magistrate have the power to say, I agree.
Well, that could happen.
You agree that could happen?
Yeah, that could happen. Yes. But the effect of the... that could happen as a matter of law and a matter of the application of the Criminal Procedure Code, but I think not as if the Court of Appeal's judgment is taken at face value.
Well, take us the bit of it which does that,
well,
because that's
yes,
a different question.
if I may. Yes. Perhaps I could take you to the head note to begin with, because as I understand, the head note is intended to be an accurate summary of the...
And that's what they've assumed, is it?
Yeah. Who drafts the head notes in these?
Well, I understand that it comes with the approval of the court.
I see.
This isn't the result. This isn't a law report as such.
No.
This is with the approval of the court. Yeah. Yes, and that's been confirmed behind me.
Maybe a bit like a summary in some other courts.
Yes. I mean, obviously, the head note gives way to the judgment, but on the other hand, I don't think in this case there's any significant distinction between them. Yeah. The beginning of the head note, I'm looking at page 374, the thrust of the appellant's contention is that her trial in the Supreme Court was a nullity, in that the offences with which she was charged are not indictable, but strictly summary offences. Therefore, the Attorney General had no jurisdiction to file the voluntary bill. Consequently, the judge could not try her. And indeed, if one looks at the argument, and obviously it wouldn't be a very useful exercise to look at everything which was said by counsel before the courts below, but that is the way that the appellant put the case throughout. And indeed, it's one of the matters which is causing the concern of the Attorney General, because we would submit that on any view, that is plainly wrong.
So you mean that's how the respondent put the case?
That's how the present respondent put the case,
Yes.
the appellant in the Court of Appeal. No,
Yeah.
I'm sorry.
Yeah.
Then there's the categorization in the next paragraph. Based on the Criminal Procedure Code, criminal offences may be classified procedurally and for trial purposes into one of three categories: summary offences, indictable offences, and a specific subset or class of indictable offence, sometimes referred to as electable offences, identified in the third schedule, which are triable either way. And we don't accept that that is a complete categorization of all criminal offences. My lady, may I, at this point, make an apology, which I'm going to have to make in a minute, sooner or later. It is that when putting the papers together for the board, we didn't, and I take responsibility for this, include all the provisions of the Criminal Procedure Code that we should have done. So I have brought the complete code. It certainly won't be necessary to look at it all, but there are some provisions in it which I think certainly the board ought to see, and it's entirely my fault that they didn't have them in advance.
I think you may find that certain members of the board have already identified other provisions of the criminal code, but
Yes.
it would be very helpful to have.
Well, we have separately copied it. I've also taken the opportunity to include in it Article 17 of the Constitution, which was referred to by Dame Allen, and short extracts from the other legislation referred to in the third schedule. But
Well, would it be a good idea if we had them now?
well, it probably would, my lady, because insofar as in a moment, perhaps not immediately, but in a moment, I'm going to need to go to the provisions. It may be more convenient to look at them all in one place.
So they're these?
Yes, and please don't be alarmed by the thickness of the first tab. It won't be necessary to
No,
look at
it's
more.
very helpful to have them, Mr.
It
Guthrie.
is, however,
Thank
very
you.
helpful, yes. Thank you.
Now, and I'd said that the second part of the head note, which is based on paragraph 18 of the judgment, is not accepted by the Attorney General. The third proposition, sections 3 and 4 of the Act demonstrate the clear intention of Parliament that the corresponding offences should be electable offences. That we don't accept, because we don't accept that electable offences and offences triable either way are simply a different way of saying the same thing.
They are, of course, in England, which is what may give rise to some scope for confusion.
Yes.
The right of election, is there not, in every either way offence here, because of
Yes.
the mode of trial provisions in the Magistrates' Court apply to all of them.
Well,
But it works differently in the Bahamas.
it works differently in the Bahamas, and we will see that, in fact, that the third schedule is more concerned, if you like, with the rights of the defendant to elect than it is concerned with the...
And is it correct that the defendant's right to elect, where Schedule 3 applies, is a right to elect for trial at the Supreme Court? He doesn't have a right to summary trial.
No, he has a right to consent to summary trial.
Well,
consent, yes.
You don't need a right to
Yes,
consent.
yes,
You
yes. He has a
consent
right
or
to-
not.
yes.
He can consent to summary trial,
Yeah.
but he has no right to summary trial. If, however, he says, I want trial at the Supreme Court, then he has a right to it. Is that the effect?
Yes, well, we need to look at more than one of the provisions. but yes,
Because in a Schedule 3 situation, the AG can say, well, never mind what anyone else says, this is going to the Supreme Court. And the lower court can itself say, this is going to the Supreme Court.
yes.
So all three can insist on it going to the Supreme Court. The defendant can insist on it going to the Supreme Court. The AG can, the court can.
Yes.
But the defendant has no right, as I see it, to stop either of the others taking it to the Supreme Court.
That's right.
Yeah.
That, I think, would be the same here, wouldn't it?
Yeah.
The right of election, so-called, is a right to claim trial by your peers. It's a right to claim trial by jury. It's not a right to tell the prosecution they can't take it to the Crown Court if they want to, as long as the magistrate agrees. Anyway,
but there are indications
right.
throughout the code, which we'll see, that there is a third class in the Bahamas, which is a class where the prosecutor has the right to elect trial in the Supreme Court without there being the option in the defendant.
Well, that Schedule 3 allows for that.
Schedule 3 allows for it in the cases where the defendant has a statutory right of election. The question in the case is whether it's available to the Crown in other cases.
That's right.
Where he doesn't.
That's the crunch question.
My Lords, in answer to, I think, an earlier question I was asked about the effect of the judgment of the Court of Appeal, the second sentence of the third paragraph of the third main paragraph on the page, that act, the code, defines an indictable offence as one which is triable only on information in the Supreme Court. Therefore, the offences with which the appellant were charged cannot be considered indictable offences. As the appellant was convicted on information in the Supreme Court and having established that the offences are not indictable offences, the only way that her trial would have been valid is if procedural provisions were made for the offence to be an either-way offence. Either-way offences are those referred to in the third schedule. However, in the present case, the necessary parliamentary action has not been taken to amend the third schedule to specifically include offences against the Act. The offences, therefore, must be considered summary offences. So that is where we say there's an obvious error because it's simply contrary to the express terms of the Act itself. The VBI procedure is reserved for persons before magistrates charged with indictable offences. As the appellant was not a person charged before the magistrate with an indictable offence, the VBI filed by the AG was done without jurisdiction, and the trial subsequent to was a nullity. We submit that these were indictable offences, but also that the procedure as set out in the code envisages the use of the VBI procedure either-way offences which are not within Section 214, so they're not third schedule offences. It's probably best use of time just to note that at sections 9 to 13 of the judgment itself, the head note is reflected by the argument which the appellant in the Court of Appeal, the respondent, made, which the Court of Appeal accepted, namely that the Trafficking in Persons Act created purely summary offences. And my lady stopped me reading sensibly the actual provisions of the TIP Act, but it is perhaps worth noting that Section 5 of the TIP Act, which deals with transporting within the jurisdiction, that does create a summary offence as opposed to an either-way offence. I think perhaps it's best to go to the Criminal Procedure Code Act. Where it's included in the electronic bundle, I'll give you the references, but we have now the whole of the code. Section 2 is on page 543 of the electronic bundle, but obviously pretty close to the beginning. I think it's page 9 of the paper version. There's the interpretation section in this code, unless the context otherwise requires. Then we have over the page, indictable offence means, save as is provided by section 214, any offence which is triable only on information before the Supreme Court. I think the Court of Appeal didn't consider whether the words "unless the context otherwise requires" could be brought in to assist. We have suggested that it could be.
I mean, that's the context of this Act, isn't it?
Well,
not the context of another Act.
well, it must be applied to whatever offence is under consideration at any particular time, and if the offence is clear.
Surely it applies to the words indictable offence where they appear in this code.
Well, unless the context otherwise requires.
Yeah, the context in which they appear.
Well, I understand the point. All right. It's not one which is capable of much elaboration on my part.
I mean, there's no doubt that if the definition stands as it is, you fail. So you have to have the context.
Unless the definition does not mean that in the circumstances of this case.
So what might the definition mean?
Indictable offence means an offence including the present offences. Which is capable of being tried.
Could you give us a revised definition?
Well, I think I have to say this has to be read as subject to the meaning that indictable offence includes either way offences, and that the save as words provide for a separate situation.
Well, you have to say that it includes either way offences which are not included in Section 214.
Yes. Yeah.
You actually have... Yes.
I mean,
you'd have to either take out the word only,
yes,
or add save as either way offences, which would have the effect of removing the words is provided by Section 214, really, wouldn't it?
well,
As you take us through other provisions in the code, could you just identify any where indictable offence is used in the sense defined in the Act?
I will take you to such references as there are, yes.
Yeah,
yes.
because it'd be helpful if you can point to a number and you say, look, there it plainly bears the meaning that the Act gives it, and there, you may say, but the situation we've got is an exceptional and a different kind.
Well, the word indictable doesn't occur very often in the Act because it's not the word which is generally in use in the Bahamas at all.
But on the footing that the definition is intended to have some meaning and to apply in at least some circumstances, it'd be helpful to see what those circumstances are.
Well, I think that economically the best way is to go through these sections in the order in which they occur, and then when we get to the ones which are perhaps we can develop them a bit further. But I was going to take you next over the page to Section 4, because it's particularly relevant in relation to the court's decision that the offences would be summary. Subject to the express provisions of this code, the Supreme Court may try any offence. A magistrate's court may try any offence in respect of which jurisdiction is expressly conferred upon such court, or upon such court when presided over by a particular grade of magistrate by the Magistrates Act, etc. Any offence under any law for the time being in force, when any court is mentioned in that behalf in such law, shall be tried by such court unless removed to any other court for trial under any provisions of this code. For the purposes of this subsection, a provision in any law for an offence to be tried summarily shall be construed as a reference to the trial of such offence by a magistrate's court.
So Section 5 takes out, does it, of Section 4A, offences such as you took us to in section 5 of TIPA. In other words, offences which by their creating statutes are made summary only.
Yes, yes, as section 5, yes. But it puts in, if you like, to the jurisdiction of the Supreme Court any law where any court is mentioned in that behalf. You appreciate, I've already, I think, referred you to the paragraph in the judgment of the Court of Appeal which says stop short of referring to it as an indictable offence. But in accordance with section 5.1, making an offence triable on information has and can only have the effect that it is triable in the Supreme Court.
What does in that behalf mean, Mr. Guthrie? Has it got a special meaning?
I think...
perhaps it just means they're mentioned.
I think it just means they're mentioned, doesn't it?
Okay.
Yeah. But I was going to carry on saying, where no court is mentioned in the manner of this section in respect of any offence, such offence shall be tried in accordance with this code. But I would respectfully submit that that doesn't apply, because it's not possible to have a trial on information without a court. It's not possible to have a trial on information without the Supreme Court. And then section 6, the Supreme Court may pass any sentence authorised by law, etc. I was going to go on then, if I may, to section 35, which refers to, it's part 4 of the Act. It's on page 21. The Supreme Court and every magistrate's court shall have authority to cause to be brought before it any person who's within the Bahamas, etc., and to deal with the accused person according to law and subject to the jurisdiction of the court concerned. And then 36, the Supreme Court may inquire into and try any offence subject to its jurisdiction at any place where it has power to hold sittings over the page, provided that no criminal case shall be brought under the cognizance of the Supreme Court exercising its original criminal jurisdiction, unless the same shall have been previously investigated by a magistrate's court and the accused person shall have been committed for trial before the Supreme Court. And we'll see in due course that the voluntary bill procedure is an exception to that. Although it will be necessary for the case to have been before the magistrate's court, there won't have been the investigation and committal in the same way. Section 45, I was going to just mention in passing, wherever any doubt arises as to the court by which any offence should be inquired into or tried, any court entertaining such doubt may, in its discretion, report the circumstances to the Supreme Court, and the Supreme Court shall decide by which court shall such offence shall be inquired into or tried. Section 54 deals with the Attorney General, it really is a general section which reflects it gives him the power to delegate the power which in fact is given to him under the Constitution to institute legal proceedings, etc. Section 73 refers to both charges and informations. Every charge or information shall contain, and shall be sufficient if it contains, a statement of the specific offence or offences with which the accused is charged, together with such particulars as may be necessary for giving reasonable information as to the nature of the offence alleged. 74. Any offences, whether felonies or misdemeanours, may be charged together in the same charge or information if the offences are charged or founded on the same facts. When more than one offence is alleged in a charge or information, it demonstrates that the person can be tried for both summary and cases on information together, I think.
Does it do that?
Well,
it looks like a mirror of the long-standing joinder provisions in English law.
I think that the reference to felonies or misdemeanours being charged together in the same charge.
Yeah, but that's not the same as the difference between a summary offence and an indictable offence, is it?
No. Well, if one...
Anyway, it doesn't matter for present purposes.
I was going to then read 75.2 at the bottom of the next of the page. Any number of charges involving one or more accused persons may, if the charges consist of offences which are founded on the same facts or part of a series of offences, be heard and determined together, unless the court decides otherwise. Then...
well, that's the one that lets summary offences be tried along with indictable ones, you say. Well, is that what you say?
Well, I think perhaps I thought I would mention it because it was there. It seemed. I think yes, I had interpreted it in that way.
Yeah.
But it is certainly the case that a felony and a misdemeanour are not necessarily on falls with summary.
The Section 5 counts were dropped. Was that because there was no jurisdiction in the Supreme Court?
I don't know. I'm afraid I don't know the answer to that question.
Very well.
It doesn't matter for present purposes, Mr. Guthrie. For what it's worth, I'm not at all sure that it is right that either 74 or 75 allows a summary offence to be added on to an indictment. We had to make special provision in England for that to be done, and I think you'll find that
it may well appear.
It may be, but it would take a bit of thinking about that.
Yes.
Fortunately, that's not the problem before us today.
Quite.
Well, I was going to go to part 5 next, which is on section 116 and deals with preliminary inquiries.
Yeah.
Whenever any charge has been brought against any person in respect of an offence not triable summarily, or which may be tried either summarily or on information, and as to which the magistrate before whom the case is brought is of the opinion that it ought to be committed for trial before the Supreme Court, or the accused person having a right to elect desires to be tried before the Supreme Court, a preliminary inquiry shall be held in accordance with the provisions hereafter in this code, which appears to indicate that there is a third category of offence. Otherwise, the words "or the accused person," the words that follow between the commas, "having a right to elect," would be unnecessary.
Well, you've got 3 there, haven't you?
Yeah.
Indictable only, not triable summarily, in line 2.
Yes.
After the first "or," magistrate says, off to the Supreme Court you go. And 3, defendant's right of election.
Yeah.
And in all 3 of those cases, there has to be a preliminary inquiry. And your case, as I understand it, is that the middle one demonstrates that there is a class of offences which is triable either way, where there need not be a right of election.
Yes. That is also confirmed, we would suggest, by section 126.
Well, there's one possibility, or it is that the offence is one in respect of which either the magistrate can say, I'm not going to try this, or the defendant say, you're not going to try this.
Yeah.
And in either of those eventualities, there must be a preliminary inquiry.
Yeah.
But the way in which it's expressed, I would respectfully submit it's at least consistent with the existence of a third category. And if one goes to 126, if at the close of or during the preliminary inquiry it shall appear to the court that the offence is of such a nature that it may suitably be dealt with under the powers by the case possessed by the court, and is not a case in which the accused has a right to elect to be tried on information and has so elected, the court may, subject to the other provisions of this code, hear and finally determine the matter and either convict the accused person or dismiss the charge.
Yeah. So either that's confined to cases where there are either way offences in the schedule and he hasn't chosen to elect, or it signals the existence of of your additional category.
Yes.
But this is the magistrate coming to the conclusion part way through.
Well, it would
It's
appear
not,
that
it's not worth committal, I'll deal with it here, isn't it?
yes, but it would appear to apply to all the cases in which he is inquiring, save, of course, I suppose, those which are solely triable. Well, even if they are cases which he is going to commit.
It does mildly suggest there's a category of indictable offences, because he wouldn't be having an inquiry if it wasn't indictable, triable on indictment,
Exactly.
in which the accused does not have the right to elect.
Yes.
It does mildly suggest that,
Yeah.
but only mildly.
I was going then to go to section 141. Every person committed for trial before the Supreme Court shall be tried on an information preferred by the Attorney General, and such trials shall be had by and before a judge and a jury to be summoned, drawn or impanelled according to the provisions of the Juries Act. Those next sections, I don't think I need read. They are referred to at a later point under section, when we come to look at voluntary bills of indictment. Part 6, which is begins with section 145, refers to subject to the provisions of this code and to any other law for the time being in force in the Bahamas. The practice of the Supreme Court in England is brought in. But one then goes to section 214.
Before we do that, can we pause on section 151?
Yeah.
For section 151.1, we do have the expression indictable offence. Let's just pause about this for a moment, because it goes back to a question you were asked earlier. No objection to information taken by way of demurrer. We're now in the Supreme Court. But if the information doesn't state in substance an indictable offence, the accused may move to quash it or in arrest of judgment. Now, it may be, on one interpretation, that does have the effect that if you're wrong, then there's no way that Section 3 of the TIP Act could be prosecuted on an indictment, i.e. whether you start by committal proceedings or by voluntary bill. Because if you start by committal proceedings and it then comes before the Supreme Court, the defendant says, well, this is not an indictable offence because it's not on its terms only triable before the Supreme Court, nor is it in the schedule. And therefore, I'm entitled to have it quashed. Have I read it correctly?
Well, that would be, he would be entitled to have it quashed if indictable is interpreted in exact conformity with Section 2.
Yeah. In other words, if that section, if indictable means what the Act says it means, then not only would the AG be stymied from using a VBI, but equally it would be futile for him to go in the old-style conventional route through committal proceedings because he'd come up against an application to quash the moment it got to the Supreme Court.
Yeah, which would seem to be an unlikely...
Well, actually, nobody suggests that Parliament thought it would be a frightfully bright idea, but that's not quite the issue before us.
Well, if that is the effect, surely it is an indication that the word indictable in that context doesn't mean.
So that goes looking at the in cases where the phrase which has a statutory meaning is defined are to be put in the column bears or doesn't bear its defined meaning. This goes into the column does not bear its defined meaning. We'll wait to find some examples which do bear a defined meaning.
Well, doesn't bear the defined meaning.
That goes in the doesn't bear its defined
Yes.
meaning column.
Yes.
Yep.
Which would indicate that it need not bear its defined meaning. I'm sorry, I was going to 214.
Yeah.
I don't know if there's anything in the interim which... 214 is, of course, the important section from the point of view that, because it's identified in the definition, where a person charged with an offence referred to in the third schedule is brought before a magistrate's court presided over by the chief magistrate, by a deputy chief magistrate, by a senior stipendiary circuit magistrate, or by a stipendiary circuit magistrate, the court shall inform the accused person that he may be tried summarily, but that he has the right to be tried for that offence by jury. Shall ask him whether he wishes to be tried by jury, etc. If he doesn't consent, the presiding magistrate shall either remit the case to some other magistrate for a preliminary inquiry or hold a preliminary inquiry himself. If he consents to be tried summarily, then the magistrate can do that, provided that the magistrate can still refuse and hold a preliminary inquiry. And then the presiding magistrate shall not in any case proceed to hear and determine summarily a charge against any person which may be tried on information if the Attorney General in writing directs that the case shall not be tried summarily.
And the effect of that, as you indicated earlier, was that it means that all three parties, that is, say, the prosecution, the defence and the court, can each independently say this is going for a trial by jury.
Yes. And I would just note the use of the words "in any case" in little b. Presiding magistrate shall not in any case proceed to hear and determine summarily a charge against a person which may be tried on information if the Attorney General disagrees. Then 215, without the derogation from the provisions of section 214, if before or during the course of a trial before a magistrate's court, in any case which may be tried summarily or on information, it appears to the magistrate that the case is one which ought to be tried by the Supreme Court, whether or not upon application made by the prosecution or the accused person, the magistrate may stay all further proceedings in respect of the trial of the matter as a summary offence, and in lieu thereof may hold a preliminary inquiry in accordance with the provisions of this code.
You need that separately from 214, do you? Because 214 is the situation where... Oh, wait a minute, go on. It may be quite important. Tell us, Mr. Guthrie.
We would submit that 215 is important because it is there because offences which may be tried summarily or on information are not only the third schedule offences referred to by section 214.
But isn't the significance of 215, at least a significance, perhaps the obvious one, is that it deals with a situation where the magistrate changes his mind as he begins to hear more of the case. 214 is dealing with position at inception, but 215 gives the magistrate the power to change his mind.
Well, it does, but it's not only, you see. 215 is before or during the course of a trial. 214 contemplates a situation where there is a right of election and is essentially providing for what we would call mode of trial procedure.
Yes.
How you go about telling him that he's got his right of election and giving effect to it, subject to the exceptions in 2. But this is, you would say, an independent decision of the magistrate in any either way offence.
Yes.
Is that right?
And if one, well, I know the side notes are not particularly decisive, but under 2141 it's procedure in case where accused person has right to trial by Supreme Court. And 215 is power of magistrate in cases trialable both summarily and on information.
So is your point that there's no reference to the third schedule there?
Yes, it's an additional provision. I mean, the reference to the third schedule, as we see, it brings in a certain number of, well, one look and see what the offences are in due course. But one of the extraordinary effects would be if Section 214 is limiting on the Attorney General's right to bring in a voluntary bill. He can do it in some extraordinary cases, such as sort of mislaid articles of post, etc., but wouldn't be able to do it in relation to the offences under the TIP Act, or indeed in the firearms offences or dangerous drugs offences.
But what's the problem about putting them into the third schedule?
Well, they aren't in the third schedule.
No, what's the problem about putting them in?
It's a question of whether there's any necessity to put them in the third schedule. I mean, it's not a question of whether...
You say it's all absurd. If there's an easy answer to this, maybe less absurd than you're suggesting to us.
Well, well, I take the point that it could no doubt be there could be a possibility for Parliament to do this if it had to. The question is, well, what are the effects of it not having done so?
Well, it might be accidental, or it might, I suppose, be conscious, because the effect, if you're right, and if you can read Section 2 in the way that you want us to, but the effect, if you're right, is that you have either way offences, which means that if you've got a relatively minor example of trafficking or a gun offence or drugs or whatever, there isn't an unanswerable right by the defendant to insist on trial by jury.
Yeah. He loses, exactly so. If the penalising statute creates penalties both on indictment and for the magistrates, and if it's not in Schedule 3, then the defendant has no right of election for trial by jury. So actually, from prosecution's viewpoint, fewer cases in Schedule 3, the better.
Well,
because the defendant, having it in Schedule 3, the only effect of it is to give the defendant, as well as other people, a say in where it's tried.
That is the way that Section 214 and Schedule 3.
it wouldn't be entirely, we don't know. It might be an oversight, but it just might not be, in the same way as there has been at least some anxiety expressed in some quarters about the right of election, for example, in relation to shoplifting of a tin of beans.
Well, I think that was the point that my Lord was making.
Yes, it is, exactly.
What is the point on 215? I'm missing that. Because it doesn't use the expression indictable offence. So it's...
Well, 215 appears to envisage a different class of either way offence than in...
And on its face, it would apply to this particular act. But does that help you? It doesn't use the expression indictable offence, so it doesn't help you on the definition of that.
But it does help because it refers to tried summarily or on information.
Yes. I think one of the easier points to make on my side of this case is that on information in Bahamas is the same as on indictment.
Yeah.
Because everyone accepts that that's the truth of the matter.
Yeah.
Well, I was then going to go on to...
it provides a means by which the magistrate can ensure that you're tried on information in the Supreme Court, but doesn't help you on what the Attorney General can do.
Well,
we'll get there, presumably.
Yes.
Right.
We'll get there in a minute.
I've been there already. I'm just trying to understand what the point is. Anyway, never mind. Carry on.
We're going through the code, so...
Yes. Well, I was going to go
methodical way.
to the procedure for indictment of offenders in
Could you pause very briefly on 218?
Yep.
Because unless I've got it wrong, 151 and 218, and in due course when we get to it, 256, are the only other places in the code where the expression indictable offence exists.
Yes.
And it's at the top. It's at the top of the second page of 218.
And it's
Whether
the
it
power
helps.
to commit for a person convicted summarily to commit them for sentence.
Convicted either way, I expect. So look.
Now, which column does that go in? The doesn't bear its defined meaning, or does bear its defined meaning?
Well, I think doesn't bear its...
Doesn't.
Doesn't.
So that's another one in the doesn't column.
Well, wait a minute.
Well, I don't know, because it refers to section 214.
Yes.
It refers to a
Yeah.
trial in the
yes.
magistrate's court pursuant to the jurisdiction conferred by section 214, which is
Election.
election.
Yes.
Having convicted any person so tried and charged with an indictable offence, wants to give him more, can commit for sentence.
That makes sense.
Yeah.
Because
Yes.
if the Crown has elected, sorry, I won't use that word, if the Crown has insisted upon summary trial and the magistrate has agreed, it would be very odd if the magistrate could then send him off to the Crown Court for further punishment. But if the responsibility, if the defendant had the right of election, then it might not be quite so odd.
I'm not sure about that. Lord Hughes will be better than I am on this, but I had a feeling that in England and Wales are circumstances where you can accept trial at the magistrate's court to which the defendant has consented, but still send him for sentence at Crown Court if at the end of it...
If you have a right of election, precisely so.
So it would apply either way. This would apply whether there was a right of election or whether you're right that this is the third category. In which
Because in England,
we put this down in the not what it says category.
No.
Well, I think in England isn't the option to send it up for sentence in any event retained because of what one might find out about the antecedents of the defendant.
It is. But in England, the whole point is, well, not the whole point, but one of the features of the English system is that if it's an offence triable either way, there is always a right of the defendant to elect. And the procedure in the magistrate's court consists of saying, now then, defendant, do you want to be tried here or do you want to be tried in the Crown Court? You're entitled to either. You ought to understand that if you choose to be tried here and we find out afterwards you've got a record as long as your arm, we may send you to the Crown Court. Now, whether that helps on which of Lord Toulson's columns this goes into is more difficult.
But which is your submission? Are you saying that this applies both where there's been what we've called an election and in what you say is the third category, or does it apply only in one of those? What's your submission?
Well, I reread the section 218. You're asking me particularly in respect of 218, is it?
Yeah.
Well, that refers specifically to the jurisdiction conferred by section 214, doesn't it?
Yes, but you've...
Yes. But whether that necessarily means that an indictable offence has to be read in the means set out in section 2 in the interpretation doesn't follow, I think.
You say that this is neutral, really, because it's referring back to the electable offences. And my Lord Hughes has given you a reason why it might make sense only to confer this power in the case of an electable offence. Might make sense. And it doesn't really take matters much further. It could be either.
It could be either, yeah.
But it certainly appears to be directly restricted to Section 214 offences.
Yeah. But the meaning, as I say, it doesn't necessarily follow that the indictable offence means.
No.
I don't know whether I've missed any reference to indictable offence before before Part 10, which refers to the procedure for indictment of offences.
Well, not unless my search engine has as well.
Well, it's my search engine that's been...
You haven't missed any others that my lord has found. So,
Part 10 then, procedure for indictment, notwithstanding Section 36, which is one of the sections that I took you through, the Attorney General may make application by summons to a judge for an order of consent to prefer a bill of indictment. Where a bill of indictment signed by the Attorney General on his behalf has been so preferred, the judge shall take the necessary action. And then, as I can go on to Section 258, which is the voluntary bill of indictment section, notwithstanding any rule of practice or anything to the contrary in this or any other written law, the Attorney General may file a voluntary bill of indictment in the Supreme Court against a person who is charged before a magistrate's court with an indictable offence, whether before or after the coming into operation of this section. And there are technical requirements for the voluntary bill. And then under subsection 4, which is relied on by the Attorney General in the Bahamas, where a voluntary bill is filed against a person who is before a magistrate's court charged with an offence triable on information, the prosecutor shall, within a reasonable time after the filing of the voluntary bill, produce to the magistrate, etc.
Did you mean to jump over 256? So did we
did deal with
I'm so sorry, I apologise. Well, how do the two fit together?
There are two different procedures, I think.
Well, we can see that.
But I don't know that they... well, I'm not sure I know...
why do you have both of them?
One of them he can do of his own initiative.
Yeah.
The other has to go to the court.
Yes. Well, I think that must be that one sees that the 258 was introduced after 256.
Yes.
So you say 256 has become obsolete?
Well, I don't know that it's become obsolete in the sense that it's no longer possible to use it. But 258 gives a different and wider power to the Attorney General.
Does 256 contemplate that there's been a preliminary examination and committal, or does it contemplate precisely that there hasn't? I mean, the opening words, notwithstanding Section 36, take you back to a section which would otherwise say that the Supreme Court can't do a case unless there's been a preliminary examination and committal.
Yeah.
So on the face of it, it may be, unless I'm misreading it, which is quite possible, that this is another form of truncated procedure, or rather bypass procedure, very like a voluntary bill.
I mean, historically, in England and Wales, when we had committal proceedings, voluntary bill was used on occasions if the Attorney General was not happy with the magistrate's decision to throw the case out. Yeah. Now, I believe the occasions when, certainly from one's own experience, it's used, are when somebody's been picked up after the others have been committed, and the trial is coming, and it's a very quick and convenient way to get all the defendants in the dock at the same time.
Well, most of the authorities about voluntary bills, and particularly in the Judicial Committee as it happens, are whether it was right for the Director or the Attorney General or whoever's able to prefer a voluntary bill to do so in defiance, if you like, of the... and indeed there are recent cases in England, I think, where an attempt was made to file a voluntary bill after a comprehensive rejection of a committal at an earlier stage to do with the Financial Services Act. But that isn't a situation which Section 258 is involved with at all, or indeed, I think,
256.
Well, the whole idea is that you can be tried on indictment without having been committed for trial by a magistrate.
Right.
But that would be the case, I think, under both 256 and 258.
Well, 258's got a wider notwithstanding provision than 256.
Yes. Yeah. Because he doesn't have to get the separate imprimatur of the judge under 258.
It has to be an indictable offence, whatever that means.
In both cases.
Yeah. But
What's the point on 2584, which you...
that refers to offences triable on information.
Rather suggesting that it means the same as an offence triable on indictment.
Yes.
Or indictable offence.
Well, it does mean the same.
Well, I mean,
Yes.
it's saying something different from a Section 214 triable either way offence. Is that the point?
Or Section 2.
Yes. But it fits in with our proposition that there are either way offences which are not solely those within Section 214.
Yeah.
The last provision at this point I was going to take you to before going to the schedule itself is 259, which is a general provision, provisions of this code and of any other law respecting the form and content of an information and respecting the proceedings on information in the Supreme Court shall apply mutatis mutandis to the form and contents of a bill of indictment and to the proceedings following upon the filing of a bill of indictment in that court, whether a voluntary bill of indictment or otherwise, as if the references in those provisions to an information were references to a bill of indictment, which seems to be really underlining the point that indictments and informations are the same in really all respects.
I think whatever else you don't establish, you're going to establish that, Mr. Guthrie.
Well, I then was going to refer you to the third schedule itself, which refers to indictable offences, which is, well, it's also in the electronic bundle, but if one can keep with this, it's on page 121, top right-hand corner. Third schedule, section 214.
Yes, I assume that on page 567 there were more offences in the third schedule, but they were chopped off, but you've now given them to us.
Well,
today.
We can tell what the offences are under the penal code because you have in the electronic bundle the penal code, and it includes the title pages.
Yes,
by
Mr.
reference
Guthrie,
across.
don't misunderstand me. I mean, speaking for myself, there's no need to understand what these offences are. I just got the impression when I looked at 567 that there was perhaps a part 4, and we now know that there is. It's as simple as that.
Yes, sorry. There is a part 4. But it is of some interest to see what the Schedule 3 offences do and don't include. And if I could ask you to have, at the same time as having that paper copy of the code open, page 578 of the penal code, which is under divider 3 if you have it in the hard copy. See, 264 is effectively common assault, and then everything under criminal harm to the person is a Schedule 3 offence. So that's from 266, causing harm, including such things as garrotting, and interference with a signal and intentionally endangering a vessel, down to person in charge of dangerous things, surgeon, etc., negligent, causing harm or danger. Then 282 is kidnapping, although the other offences of between 283 and 288 are not included. Then over the page, homicide, the only one there, which is within Schedule 3, is 297, concealment of the body of a child. Then 315, negligent and intentional libel, is a Schedule 3 offence. Under arson, causing damage by fire or explosion generally, that's 327. Then all the offences under other criminal mischief are Schedule 3 offences, including criminal diversion of letters from the addressee, abstracting of electricity, for example, and sweeping up provision, damaging cases not provided for. Then all the offences under robbery, fraud, and extortion, 339 to 341, so including stealing a will or codicil. 342 and 343 are not in the schedule, but 344, being a common thief, stealing and extortion are, and so are everything from 344 to 359, which goes down to common receiving and includes false pretenses and other frauds. 362, housebreaking.
What's the point you're trying to make, Mr.
Well, I just thought it was, it is odd to find, if you like, if the definition is the determining factor, the definition in section 2.1, the ability to prefer a voluntary bill of indictment being permitted in all of these cases, which vary from, fairly trivial to quite serious, and to find it excluded by implication from the acts, namely the Trafficking in Persons Act, the Firearms Act, and the Dangerous Drugs Act, where the right to trial on information is expressly, or the provision for trial on information is expressly made by Parliament in terms. One might understand if there was a scheme whereby voluntary bills of indictment were only to be used in cases of a certain gravity or of a certain nature. But that obviously isn't the case in the Bahamas. If there would seem to be no identifiable purpose in permitting the use of the procedure in what may be said to be almost everything, but not these serious offences in which trial on information is expressly provided for in the statutes creating the offence.
These are all described as indictable offences as defined, but of course the indictable offence definition in the Penal Code simply takes you back to Book 3. Do we know whether all these are offences which are only triable on indictment, other than where they get into Section 214, or...
They are certainly triable on information. I've also included
Yes,
at
but
the
we're
end of the-
equating that with on indictment.
Yeah. Because the Part 2 and Part 3 of the third schedule are separate from the penal code, I've included those, or the relevant parts of those, in the same bundle of authorities which I've handed up. You'll see the explosive substances should be, I think, under the third tab. See that section 5 is solely on information, or it only refers to provision for information, travel on information.
But are those all travel on information?
Yes. The only section in the explosive substance action is, I think, section 5 under Schedule 3. That's, so it's only offences for making or knowingly having possession of an explosive substance.
But forgive me, Mr. Guthrie, the penal code has, as you've pointed out somewhere, its own definition of indictable offence.
Yes.
In the definition section right at the beginning, we've got it on page 593.
Yeah.
And it simply says, means any offence punishable under Book 3 or under indictment under any other law. But my Lord's question was, I think, whether the Book 3 offences were ones which were triable only on indictment. And if they include things like common assault, I'm a little bit surprised.
Well, I think I haven't printed out, I'm afraid, the whole of the penal code, but I could do so. I could check that point.
We don't need the whole of it.
No, but I could check.
Well, it looks pretty unlikely. If you look at the title,
Yes.
if you look at the index, Book 3 is on page 578, and it begins with Section 262, which deals with those of its, presumably those of its charges, which are capable of being tried summarily. So it doesn't look as if everything in Book 3 is not only indictable, but indictable and not triable summarily.
Yeah.
In fact, and it would perhaps be rather surprising if that were the case.
Let's give it a moment.
Well, we don't know what Section 262 says.
No.
Where a person is charged before a magistrate with an indictable offence under this code, and it appears to the magistrate that such charge could have been laid as for a summary offence under provisions of Book 2, then the magistrate may do various things.
Let's have a look. Book 2. Oh, I see, yes.
I think that's really where the same facts would have supported a summary charge.
Yeah, you get assault in both Book 2 and Book 3, so, yeah, okay.
A different point.
Yeah.
But I'm sorry, it's my fault. I can check the matter, but I don't know whether you would get, for example, taking fish in private water. There are some which would certainly not apparently be only on information.
I think the point, I mean, it looks to me, looking at the penal code, is that all these offences under Book 3 are ones where they're assumed to be triable only on information. What the list of offences simply says what the penalty is.
Yeah.
But if the facts are such as could have founded a summary charge, then the magistrate can say it should be dealt with under that. So I think it's consistent with the idea that there's a whole class of indictable offences which are only chargeable on indictment or on information.
Well, I was finally just going to tell you what Section 44 of the Road Traffic Act was. It's causing death, effectively, by dangerous driving.
Which one?
The last part 3 of the third schedule refers to the Road Traffic Act.
Yeah.
And that offence is causing death by dangerous driving. It's the should be on the last page of the bundle that I gave you.
I mean, the pattern is that the penal code defines things as either summary or triable on information. Then section 214 clocks in and says if they're in the third schedule, then they're triable either way on election.
Yeah.
So that all suggests a fairly clear pattern of three categories and doesn't necessarily support a fourth category.
Well, the fourth category would be supported by the acts which refer to triable I
mean, the problem I see, is that when it says you have a specific definition in the code which applies unless the context otherwise requires. And that doesn't mean the context otherwise suggests, or that you can find, if you dig around long enough, something which might be consistent with a different view. I'm looking for something which actually requires one to take a different approach as one.
Well, we would say it does go as far as that, if you have the...
you have to, I think, yeah.
Those were the references in the code which I was to take you to. And I've made the point that if the power under Section 258 is construed as subject to the interpretation of Section 2, the Attorney General will be able to prefer a voluntary bill for common assault, but not for the offences, the serious offences which are created under not only the TIP Act, but also the Firearms Act or the Dangerous Drugs Act. Lord Hughes has already referred to the definition of indictable offence under the penal code itself, which is, well, you've seen what that is. It's at page 593 of the record of the, a bundle of authorities. I mentioned there's the definition of indictable offence means any offence punishable under Book 3 or punishable on indictment under any other law, which of course would bring in the law with which we're concerned. There's then the next definition, indictment, includes a criminal information triable before a jury. And of course, either of those definitions would suit my case or the Attorney General's case. The Court of Appeal's reasoning in relation to the code is really summed up at, I think, paragraphs 17 and 18 of the judgment. Which is on page 378. It's at paragraph 18. Criminal offences may be classified procedurally and for trial purposes. And then that, of course, is the classification to which the Attorney General objects, because the classification is not complete. The other aspect of the Court of Appeal's judgment I wanted to refer to is the reference to the two cases, both of which are in the authorities bundle. And there's Kenzo Kemp is at divider 4. And and Ralph Ward is at divider 6. But those cases, first of all, they both concerned offences which are within Schedule 3. And the issue which the court had to decide was whether that made them indictable offences. And the point was being made, I think, by Mr. Ducille, who also represented the respondent in this case in the Court of Appeal, that the definition in Section 2 of indictable offence did not include the Schedule 3 offences because I think, I may not have entirely understood his argument, but he thought the word save as somehow accepted those. Well, we would submit that that was plainly wrong. And so neither of these cases have the effect of deciding whether or not there is a class of offence which permits the Attorney General to proceed by way of indictment in suitable circumstances.
I rather thought that in the Kemp case, as you say, this was listed in Schedule 3, this offence.
Yes.
I think, correct me if I'm wrong, the 6 months for a case before the magistrate had expired.
Yes.
And so Mr. Ducille was saying, well, it's no longer an either way offence, because it can't be heard in the magistrate's court now. Yeah. So there can be no valid voluntary bill, which the Court of Appeal said, no, Mr. Ducille.
Yeah, and possibly not very surprisingly, because it came within the definition. But I think he was trying to say that somehow he could pray and aid the save as point.
But, I mean, insofar as in the grant of permission to appeal to this court, there's some suggestion by the dissenting judge that these cases really concluded the issue. I think you're entitled to say they don't.
Well, they don't, no. That's the only point that I'm really making in relation to these two authorities. I didn't labour it then, obviously, in the circumstances. But one is left with the position that the Attorney General is proceeding to do effectively what Parliament has intended by creating the offences under Section 3 and 4 as indictable offences. And it is really plainly, we say, and obviously wrong, that they are summary offences, or that they are only summary offences, or strictly summary offences. The only question is if that is the position, whether the definition in the criminal code is determinative of the question, whether or not he could proceed by way of indictment as he can in all other cases where the cases are triable either way.
Do you need to venture on an active construction of Section 2 if your object is only to achieve the position that a Section 3 TIPA offence can be taken to the Supreme Court? Or do you need your active construction of Section 2 only if you also want the power to grant a voluntary bill under 258?
Well, obviously the Attorney General considers that both those things go together.
And you're right to say that the Court of Appeal appears to have said that, but here where we start from scratch, do they necessarily go together?
Well, the only it depends on whether if the if the definition is rewritten, so to speak, then they go together. They can go together, because if it's an indictable offence, which we say it is, then it falls squarely within Section 2581.
Follow that.
But I would respectfully submit that that would be plainly what was the intention of the Bahamian Parliament in enacting the TIP Act as it was in the Firearms Act and the Dangerous Drugs Act.
I don't think, respect, you're meeting Lord Hughes' point, which is, is this a problem both in relation to a VBI and also in relation to proceeding through the Magistrates' Court and so reaching the Supreme Court? Yeah. Otherwise, does it matter? The consequences of the AG are obviously that much more serious if he can't reach the Supreme Court either way than if he can reach the Supreme Court one way.
Well,
that, and whether you can draw a distinction between the two brings us, I think, back to Section 151, which we looked at.
forgive me.
Yeah.
Because the argument would be, well, if the argument is sound in relation to a VBI, it would be equally sound if the AG went through the Magistrates' Court route, got to the Supreme Court, at which point the defendant said, Section 151, quash the indictment, please.
So it can't mean that in Section 151.
But I mean, Lord Hughes was really seeking your assistance on whether this was an all-or-nothing situation.
We would submit, as I say, that one goes with the other. I appreciate that may not be.
But what you really want is that they both go together.
Yes, that's what I really
But
want. I'm sorry I'm so transparent. I'm sorry I'm so transparent.
If, on the other hand, the view is taken that you can have one without the other,
well, that would be better than leaving the law as it is. That would be better than leaving it on the basis of the Court of Appeal's decision.
Yeah.
But I do repeat, it seems rather extraordinary that the result might be that the effect was to deprive the Attorney General of his ability to bring the matter before the court in the way that he can in relation to...
If the respondent were represented, she might say two things about the additional category. One, that really doesn't have any reflection in the Criminal Procedure Code Act one can see, and secondly, that there is something potentially objectionable about not giving a defendant a right to trial by jury in circumstances where, after summary trial, they may then be committed for sentence and face a possible 15-year sentence. Those arguments, I imagine, would have been advanced by the other side.
Well,
do you have anything to say about them?
No, I don't accept that there's anything offensive in the ordinary prosecutorial discretion to decide whether to proceed by indictment or not, because the prosecutor could achieve the same result on the provisions which we've seen
No, that's not the objection. The objection would be that this additional category enables the prosecutor not to proceed on indictment, but to proceed summarily, and if there's no right to jury trial, there is a potential exposure to a very long sentence by somebody who's had no right to jury trial.
Well, hang on. I don't think that's right, is it? If you look at 218, we've been through this, but 218 is 218. It does not give a right to commit for sentence for all indictable offences.
No, you have to have a bad record.
No. You have to have a third schedule offence.
Yeah.
We've been through this.
Sorry. So there's... Let me just...
Magistrate, before there can be a committal for sentence under 218, the magistrate has to be acting under 214.
Fair point.
That was why Lord Hughes was suggesting it could make sense.
Yes. No, quite right. That's no... Yes. Thank you.
The only other matter which for completeness sake, because it was mentioned by the court, is the basis for the Attorney General's ability to prefer a voluntary bill of indictment. One has to remember that the Criminal Procedure Code is something which deals with procedure. The Penal Code creates the offences, and indeed, as the Dame Allen said, the voluntary bill procedure has its origin, well, in the Bahamas. It probably has its origin a good deal further back than the written constitution of the Bahamas, because, as we know, it's a very old part of the criminal law. But I did include, because the court included it, the relevant part of the Constitution, which you should have under Divider 2. It's the chapter which deals with the executive. Section 78 is on the 3rd page. The Attorney General shall have power in any case in which he considers it desirable to do so, to institute and undertake criminal proceedings against any person before any court for any offence against the law of the Bahamas. As I say, the procedure code being solely concerned with procedure, the question is whether it's right to see his authority, or the voluntary bill of indictment being part of that, as being determined by what we would submit as a rather unsatisfactory, if you like, definition contained in Section 2, the interpretation section. I hope that, having seen the problem a little nearer to seeing the way through it, perhaps.
What are the implications for if we were to uphold the Court of Appeal's decision? I mean, are there a lot of cases waiting?
I understand there are. For example, this particular respondent has taken the opportunity to go back to her native Jamaica, and I suspect will not be seen again. Sam, who I don't know to what extent you read the...
I'm not so concerned with
two or
three particular ones, but generally.
He's awaiting his prosecution. Yes. There are exactly the same situation applies under the Firearms Act and the Dangerous Drugs Act, which are not third schedule offences, but provide in exactly the same way for summary conviction or conviction on information.
Are there other drug trafficking statutes, or is that the only drug trafficking statute?
I'm afraid that's a question I can't.
Because if it is the only drug trafficking statute, presumably the consequence of the Court of Appeal decision is that unless and until Parliament acts, no drug trafficking operation, however large, can be dealt with otherwise than summarily.
Well, that was the effect of the submission being made by Mr. Ducil. Yes. Reading the argument, what he's saying is that firearms offences can only be tried summarily, drugs offences can only be tried summarily.
Right, and trafficking.
And we see that the argument has been success in the last of the cases, which is included in the authorities bundles. I think it's at Divider 5 is Giovanni Garland. His indictment has been quashed on the basis that there was no right to prefer a voluntary bill of indictment. And of course it may be that some convictions, I'm afraid I can't, would be liable to be set aside just as this respondent's conviction.
Well, that was importing a single firearm. There may or may not be other offences which are indictable only and thus can be prosecuted where they are serious. But I don't know.
When were the TIP provisions introduced?
Give me a moment.
10th of December
10th of December 2008.
And the Criminal Procedure Code?
Well, the
those-
code itself is ancient. It goes back to 1969, so not as ancient as all that. But the particular provisions, section 214,
Yes.
was introduced in 1996.
So
Section 258.
TIP comes in after section 214.
Yes.
Yeah.
Do you want to advance any argument based on that?
On the basis that the just formulating it in my head, my lord.
It's a statute, isn't it?
We could make what we will of that.
I was just going to also add that the 258 procedure came in 1995.
All of this is before.
All of this is before the
Yeah.
the TIP Act. I mean, I don't know whether, as I say, I've been you understand where the Attorney General is.
We understand
situated.
entirely where the Attorney General
Yes.
is situated. We understand the problem. We will obviously have to consider what we make of the answer.
Yeah. And I think I should say that the Attorney General is grateful to you for having expedited the hearing of this appeal, because it has caused considerable concern in the Bahamas.
Well, if he gets the wrong answer from the board, he will obviously have to make representations to those
Yes, well, he'd
who
probably
promote legislation.
he'd still be grateful for having it sooner rather than later.
Thank you, Mr. Guthrie. I think we have asked you all the questions that we wished to ask you. We are most grateful to you for your representations, and the board will, of course, take time to consider what advice they will humbly tender to Her Majesty. Court is now adjourned.